Um, so I'm not really sure how to pose my question. Is it possible that those that don't have a chat box maybe just raise their hand at the end of the section?
Yeah, I don't have one either.
All right. Prudence.
I'm here.
So the chat box. I would assume it's show conversation. Am I correct?
It
It's
is.
next, and it's next to the raised hand
That's
icon.
correct. Yes, I can see most delegates have access to. Maybe to those who don't have access at all, they can use the hand gesture during the question and answer session. Or if they are comfortable, they can just email their questions to me. I can forward them to you.
You can forward it to me.
Yes.
Perfect. All right. I think it's safe to say that we can start, Prudence. Is that fine?
I've started the recording, yes.
All right. Okay, so in a nutshell, we're going to be doing matrimonial law in literally a space of a couple of hours. But what you are learning here today, it's just the basics. It's the basics for you to continue. And a lot of what I'm going to be presenting today is probably what you've also done or what you've also learned in university, but obviously we're just going the extra mile as to show what the procedures are as well. So I've presented, my presentation today is via your PowerPoint. And if there are any persons that would like the slides, please don't hesitate in maybe contacting Prudence, and I will then forward the slides to her so that she can make the slides available to you. So first point of call, we are going to discuss the various types of marriages in South Africa. And as you can see from the slide, you have 5 types of marriages. You have your civil marriages, you have your customary marriages, your civil unions, your Hindu marriages, and your Muslim marriages. Now, if we look at our...
Sorry, Janine, I just want to say, the person that said now earlier on that there's no chat, I actually logged off. I left the screen and I came back on and it was on. So that usually happens if you log off and you log on, it will come back on.
All right, noted. Okay, so your civil marriages is regulated by what we have always known, and that's your Marriages Act 25 of 1961. That is what all of us mostly know and what we maybe even grew up with, okay? So the requirements for marriage in terms of the Marriages Act is that it's between a man and a woman. It is solemnized by a registered marriage officer. The person must be 18 years and older. Now, if the person is younger than 18 years, they usually require the consent of their parent as well as the consent of the Minister of Home Affairs. Now, if there is no parent or if there's no legal guardian, what will happen is you would need to apply to the High Court, who is the upper guardian of all children, for consent for marriage to take place. Or the minor can also approach the court for an application to be declared an emancipated individual. Okay, and I'm sure a lot of you did do or studied what emancipation means at university, but it's basically you are being declared a minor before you, by a court of law, before you actually turn 18 years old. Okay, so your next requirement then is that the marriage takes place in a building with open doors as well as a roof. Now, ex parte Dow, also another case which I've also known from university, the husband tried to make an application to court to have the marriage declared invalid. However, the court dismissed his application and then said, for all intents of purposes, the intention of the parties was to conclude a valid marriage. And just because the marriage occurred in a garden did not render the marriage invalid. Okay. So I think he really tried to take a chance there to try and get out of the marriage. However, it didn't work. But you would really need a lot of substance to get out of a marriage. So you would need to say that I believe this person was 18 years old, or 27 years old, and I only found out that she was 15, after we got married. Or, yeah. So in other words, we got married under false pretenses. You could also say that he or she didn't have the consent of the parents, and the consent of the parents is now being withheld. So there must really be really valid reasons. Okay. So then also the marriage must take place between 8 and 4 p.m. And then both parties must be present, and you have to have 2 witnesses. That is a very, very important requirement. But requirements such as 8 a.m., between the times of 8 a.m. and 4 p.m., and being in a building under a roof, it is not really substantial reasons for a marriage to be declared not valid. Okay. So then let's just move on to the next one, is our customary marriages. So customary marriages today is regulated in terms of your Customary Marriages Act. Okay, Act 120 of 1998. Now, a customary marriage is any marriage which is negotiated, celebrated, and concluded in terms of any one of the customs or indigenous African customs in South Africa. And the requirements, therefore, is that the person must be 18 years and older. If younger, again, the person needs the consent of the parent or the Minister of Home Affairs or a legal guardian. If no parents, you will then apply what I've stipulated happens in terms of the Marriages Act. Okay? You would need both parties to consent, so the parties are not to be forced. And then it must be celebrated in terms of customary law. Then you can see over here, I've placed a question: can a spouse in terms of customary law enter into a civil marriage in terms of a Marriages Act? Yes. If the person who wants to enter into a civil marriage in terms of customary, in terms of the Marriages Act, if that person is married to the same person to whom he is married in terms of customary law, then yes, you can conclude a civil marriage with that person in terms of the Marriages Act. But neither of them must be in a customary marriage with another person. All right? So that is the only circumstance under which you can conclude a marriage in terms of a civil marriage in terms of the Marriages Act, is if you are marrying the same person to whom you are married with in terms of customary law. Okay, and then the case law reference there is Tembisile versus Tembisile. I encourage all of you to please go and read the facts of the case, and also remember that when answering questions during an exam, that you cite case law. Now, how would somebody know if you have concluded a customary marriage with another person? Well, what you should do once you've concluded a customary marriage is that you should register the marriage within 3 months after the marriage has taken place at Home Affairs. At Home Affairs, you will then get a certificate, and this certificate is your prima facie proof that you actually got married or that you are married in terms of customary law. Now, non-registration of the customary marriage does not affect the validity of the marriage. All right? So what is the matrimonial property regime? In other words, is it in or out of community of property? Well, marriages which took place, apologies for my spelling over there, marriages which took place before 15 November 2000 was automatically out of community of property, excluding the accrual system. All right? Then it was constitutionally challenged, or it was challenged in a court of law, and it was then declared that all marriages after 15 November 2000 was automatically in community on property unless the parties, like in a civil marriage in terms of the Marriages Act, decides that they want to actually conclude a marriage out of community of property, either with or without the accrual system. All right, so now parties in terms of a customary marriage, like parties in terms of a marriage concluded in terms of the Marriages Act, has a choice. They have a freedom of choice to choose which matrimonial property regime they would like their marriage to be, or the matrimonial property regime to be regulated by. All right. Now, what if a spouse wants to conclude a further customary marriage? All right. You'll remember my question earlier on. The question earlier on is, can a spouse in terms of customary law enter a civil marriage in terms of the Marriages Act? The next question is, what if a spouse wants to conclude a further customary marriage? So he's already in a customary marriage with Janine, but he wants to conclude another customary marriage with a second or third party. Then we look at section 7(6) of the Customary Marriages Act. That will be your guide. That will be your go-to point. The spouse so the spouse will be the applicant, and he will make an application together with his other proposed, his current spouse will make an application to court to approve a written notarial contract which will regulate the future matrimonial system of the marriages, of any other marriages which he may conclude. And if a spouse ignores the regulations in terms of section 7(6), which you will then read in MN versus MM, and concludes a second marriage, this marriage will be valid, but it will be out of community of property. All right? The first marriage's matrimonial property system will then continue to subsist. So again, let me just say that again. So if a spouse ignores section 7(6) and does not apply to court to have a contract approved which regulates his future matrimonial system with any of his other the other spouses, then the second marriage will automatically be considered out of community of property. And the first marriage's matrimonial property system will continue to remain the same. All right. So now civil unions. Civil unions are regulated by the Civil Unions Act of 17 of 2006. It regulates same-sex and heterosexual couples who may enter into a marriage or a civil partnership in terms of this act. And also, let me just emphasize, the word civil union refers to both a marriage and a civil partnerships. Parties can refer to either word. So you can say I am married to the person, or you can say I'm in a civil union with a person or a civil partnership, but it, for all intents and purposes, civil union refers to marriages which are concluded in terms of the Civil Unions Act, and it applies to same-sex and heterosexual couples. Okay? So again, I stated what is a civil union. It is a voluntary union between two persons, 18 years and older, solemnized and registered in terms of the procedures of the Civil Union Act. The same consequences as the Marriages Act 25 of 1961 will apply. In section 6 of the Act, no religious person, so no priest, no imam, part of a religious denomination can be forced to marry a same-sex civil union partner. All right? So that just absolves any religious leader, priest, imam, or any other religious leader from being taken to court on the grounds of discrimination. Section 8.2, if married in terms of the Civil Unions Act, a marriage in terms of customary law, or the Marriages Act of 1961 cannot be concluded. Please take note of that. If you are married in terms of the Civil Unions Act, you cannot in terms of customary, you cannot be married in terms of customary law or a civil marriage in terms of the Marriages Act. So the Civil Unions Act makes no provision for divorce. So therefore, we will also refer to the Divorce Act 70 of 1979, which regulates or which deals with civil marriages in terms of the Marriages Act of 1961. All right, here you will notice I've said same consequences as the Marriages Act 25 of 1961. So please keep that in mind. So now our next marriage, which we're going to be dealing with, is our Hindu marriages. Our Hindu marriages, unfortunately, is still not recognized by our South African law, merely because there is so many diverse groups within the Hindu marriage that there doesn't seem to be a uniformity on how the marriages will be regulated if recognized by the South African law. However, the South African Law Reform Commission is looking into this. And legally speaking, Hindu marriages cannot be dissolved. And therefore, for now, couples should validate their marriage in terms, excuse my spelling again, in terms of the South African law. Then our next and final marriage is our Muslim marriages. Please note, Muslim marriages are not legally recognized in terms of the South African law. The Muslim Marriages Draft Bill was introduced in 2010. But there is some light at the end of the tunnel. Some recognition is being afforded. So if a party were to want to lay claim to inheritance in terms of deceased estate, or may want to lay claim to a pension fund, then there are the courts have offered some relief. In the Western Cape, we refer to R versus R, which is a 2015 case. And the court found that the law is developed to include religious marriages and therefore afford marriages to gain limited recognition, resulting in spouses being able to inherit from a deceased estate or claim maintenance. Again, candidates, I'm urging you to please read the relevant case law. The summaries which are in my notes are not enough when answering a question, and you need to substantiate even more. All right, to make you understand, or to make the person who is marking your papers, to let them know that you understand the concepts. All right, so please do read and cite case law when answering your questions. So now we're going to move on. So we've now dealt with the various marriages. We're now going to deal with the matrimonial property regime, which regulates a particular marriage. Okay, so let's go. So in South Africa, we have 3 matrimonial property systems. We have in community of property, we have out of community of property without the accrual system, and then we have out of community of property with the accrual system. So those are the 3 you need to familiarize yourselves with. Now, in South Africa, or I suppose in many of our backgrounds, we grew up in homes where our parents are married in community of property. And this is the most, or this was, I'm not sure if it's still the most popular property system, but it was the most popular property system. So with the system, whatever was accumulated prior to the marriage in terms of assets and whatever was accumulated in terms of liabilities, upon marriage, it becomes part of the joint estate. So your husband's assets and liabilities become your assets and liabilities. Both of you can be held accountable or held accountable for each other's estates. Now, consent is needed when both parties need to alienate or encumber assets. So if you would like to buy immovable property, for instance, you would need your spouse's consent. If you want to get rid of any assets, you would need the consent of your spouse, all right? No consent is needed in your ordinary course of business, professional trade, and assets and liabilities before the marriage become part of the joint estate. Also, what I want to mention to you is that each spouse also automatically shares in the growth of the estate. The other parties or the other person's credit worthiness also becomes part of the estate. And so when consulting with clients on the various property regimes that they can, you need to advise them as to the pros and cons of each system, all right? So you need to, particularly if you're dealing with a businessman, for example, you need to explain the consequences of him being married to his wife in community of property, right? So if he, for instance, becomes sequestrated, unfortunately, the entire joint estate becomes sequestrated, right? Then you will see, I've said here, except testimony assets may be excluded from the joint estate. You will notice that in a will, there is, or in a final will and a last will and testament, there will always be a proviso which stipulates that the testamentary assets which the person will be inheriting is excluded from community of property. Okay. Now, a bodily injury which is caused by the other party, the patrimonial damages which is claimed from that person who caused the bodily injury is excluded from the joint estate. Okay. Now, fraudulent alienation of assets, various common law remedies are available. If you, at divorce, you become aware that your client's husband is alienating or getting rid or disposing of assets, you need to bring an application, an anti-dissipation application can be launched. Now, again, this is a very drastic remedy, and you need to show to the court in your application, when drafting the application, you need to show the court that there is no other alternative remedy and that this remedy is urgently sought. It's urgently sought on the basis because your client has already sold the BMW motor vehicle and he's sold off various stock exchange shares, and he's slowly but surely trying to deplete the assets in that forms part of the joint estate. Okay, so then if assets is in possession of another person, you may launch the actio pollina utilis application. Okay, that is to recover the possession from the other person. If you are unable to recover the item from that person, you will then have a claim against the spouse in your during your divorce action. What I would also recommend is that it is also a very good ground for forfeiture, partially or partial forfeiture or whole, whole forfeiture of the grounds you can claim forfeiture on the grounds of serious misconduct. Okay, so this is a very good ground for forfeiture in the instance. You can then explain to the court in your summons for divorce that this is the misconduct with which the or how the other party or how the defendant is conducting himself, and you are asking for forfeiture of, for instance, your client's pension fund, and forfeiture against any other asset that your client may have. If the spouse recklessly squanders assets, you have a court application. You can have a court application done, or you can make an application to court to have the person declared a prodigal. Again, I'm sure that is a term you learned or you familiarized yourself during university days. And so a prodigal is somebody who recklessly squanders the assets of the joint estate. Right, so that is your marriage in community of property. In general, also let me just in general, what happens in community of property, and upon this, you would generally, the entire estate would need to be equally shared between one another. Okay. To look at, we turn our attention to outer community of property with the accrual. Now, to me, this is the most complicated property regime ever, and I personally don't like advising my clients merely because there's so much administration that needs to be dealt with at death or at divorce, but you will see for yourselves in a bit. So it's also regulated by the Matrimonial Property Act 88 of 1984. So what is out of community of property, including, it's the sharing of profits made during the marriage. So it's where the larger estate will transfer 1/2 of the difference to the smaller estate. If you are confused by that one, we will get to an example shortly. So it's where the larger estate transfers 1/2 of the difference to the smaller estate. Assets held prior to the marriage can either be included or excluded. Again, I will add more clarity to that here below. So what is exempted from outer community of property with the accrual? Inheritance, donations, non-patrimonial damages are excluded from accrual unless otherwise stipulated in an ante-nuptial contract. So anything that you want added to the nuptial contract, you need to have it specifically stated, right? So when is the net value of each estate determined? Now, the net value of each estate will only be determined at death or at divorce. And also keep in mind, also in terms of out of community of property, will apply for forfeiture in terms of Section 9, right? So you could ask that the spouse not share in the accrual due to various reasons, misconduct, all of those things. But we will get to forfeiture in a bit. How to determine the net value. So often when you draft, and I'm not sure how many of you are involved in the drafting of ante-nuptial contracts, but if you draft an ante-nuptial contract, with the accruals, which includes the accrual system, you can advise your clients to start their commencement value at 0. Okay. So whatever they may have brought into you, so you could exclude what they currently have before they get married. So let's say Janine has a car and Lee has a house. You can exclude those values and you can start the commencement value at 0. So you will then only start calculating the value of each estate as from date of marriage, which will be 0. Okay. So then if you do not exclude the value, so if my car was worth R1 and his house was worth R1, the commencement value of each of the estates would be R1, right? So how you will determine the net value at death or divorce, you would list all the assets at present value, then you would deduct the commencement value. Now the commencement value, you adjust in terms of CPI to make provision for the change in the value of money. So what happens here is that the value of that thing may not necessarily be R1 or as at 10 years ago versus today at the commencement, or the value of money at that stage is not the same in terms of then commencement value as exclude inheritance, you would deduct the legacies, you would deduct donations, non-patrimonial losses, debts and liabilities. That will then give you the net accrual. Okay. Then the accrual claim is half of the larger estate minus the smaller estate. So let's go to a practical example. So if husband and wife is married out of community of property, with the inclusion of the accrual at the time of marriage, at the time of marriage, husband has a study loan of 10,000 Rand and no assets. Wife has no debts but savings of 20,000 Rand. And you will note there I've put a sentence here which says, let's assume that in terms of CPI, money is worth 2 times now. H dies 5 years later and leaves a net estate of 250,000 Rand, composed as follows. His intestate inheritance of 25,000 Rand, his defamation damages of 25,000 Rand, his assets equal 200,000, and then that gives us his net estate value of 250,000 Rand. Okay, so that is how husband's estate is comprised. At husband's death, the net value of wife's estate is 70,000 Rand. Do we then calculate the accrual? Well, we'll say we'll take husband's net value at dissolution or death, which is 250,000 Rand. The net commencement, now keeping in mind his net commencement value, because he had no assets, his net commencement value is 0 Rand, minus assets not part of the estate. Now, not part of the estate, we go back to the theory part of it. We need to exclude assets excluded. We need to exclude inheritance, legacies, donations, non-patrimonial losses, debts or liabilities. So then we will take his 250,000 Rand minus his net commencement value, which is 0 Rand because it says he had no assets, minus assets not part of the estate. So again, back to your theory, always have your theory in mind. His inheritance does not form part of the estate, and his defamation damages, which is your non-patrimonial losses, will also be deducted. So we will say 250,000 minus 50,000 Rand. H's accrual therefore is 200,000 Rand. W's estate, net value at dissolution or death is 70,000 Rand, minus her commencement value as adapted by CPA, which is ×2. Now remember, in our example, we said that W, wife, has no debts but has savings of 20,000 Rand. We times the 20,000 Rand by 2. That is where you get your 40,000 Rand. So your 70 minus 40,000 Rand minus assets which did not form part of the estate. She didn't have anything else. So therefore, 0 Rand. As for my spelling it again. So W, the wife's accrual would be 30,000 Rand. We would then say W's accrual claim equals half of 200,000 less 30,000. It's equal to 170,000 Rand. Half of 170,000 Rand is 85,000 Rand, and therefore W's claim is for 85,000 Rand. I would encourage everybody just to do some exercises, familiarize yourself with how you would explain the calculations to your clients. I also just want to say this is a very, particularly where there are larger estates. But even if the estate is not too large, you would still need to get a whole range of documents, such as the list of assets, the value of the items. So it's a very complicated process, and could involve quite a bit of money if you need to call in the professionals. So if you need to call in auditors, accountants, all of those things, then it could become quite expensive for your client. Just something to note during antenuptial contract consultations. When you describe each particular one, you need to keep costs in mind as well. All right, so I've just copied and pasted a picture of the advantages and disadvantages of out of community of property with the accrual. There is still a total separation of the estates. The administration of each estate is uncomplicated during the listen to what they're saying. During the subsistence of the marriage, it's uncomplicated. But trust me, it becomes complicated after at dissolution of the marriage or at death. So spouses may freely contract with one another. Spouses are not liable for each other's delicts or criminal fines. So everything typically the same to out of community of property without the accrual. All right. So these are the advantages and disadvantages. I encourage you to please have a look at that. Right, let's go to the, I'm just going to allow, let's go to outer community of property without the accrual. Here's a complete separation of estates. No right to share in the growth of the estates. Possible claim of spousal maintenance at divorce. Less complicated at death or dissolution. Very important to execute a last will and testament in this instance. It is vitally important that parties conclude a last will and testament anyway, but if at death you would like your spouse to whom you married out of community of property without the accrual to inherit, please note that the last will and testament is very important in this instance. All right. Also, a lot less complicated at divorce. Each party goes their separate ways. There is a possible, like I said, there is a possible claim of spousal maintenance depending on the circumstances of the respective parties. But we will get to maintenance in a bit. Okay, right. So now we get to changing your matrimonial property system. There are many occasions when parties say, I didn't intend on getting married in community of property. We actually wanted to get married out of community of property. They then do have recourse. They can make an application to court to have the matrimonial property system completely changed. All right. Requirements, so it's regulated by Section 21 of the Matrimonial Property Act. The requirements are that the parties apply jointly, so they make the application jointly. You need to state the reasons for the proposed change. The registrar must be cited in your application as a respondent and must also be served. And you must also indicate in the averments in your affidavit that no parties will be prejudiced by the change, right? You also need to give sufficient notice. Creditors, a notice needs to go in the Government Gazette, your local newspaper, and 2 weeks before the hearing of the matter, proof must be submitted in your affidavit. A letter to all interested parties, in other words, a letter to all creditors must also be submitted in your affidavit. So everything that you have placed in the Government Gazette, as well as everything that has been, so you're noticing the Government Gazette, your local newspaper, your notices and letters to creditors must be attached as annexures in your affidavit. Please do not forget that. It needs to be attached. Do not stand before a judge and the judge says to you, but where are your newspapers and where are your Government Gazette clippings? And where is all your proof that no prejudice will be suffered by any of the creditors or any other persons, you know? So please place as much information in your affidavit as possible. So here I have a change of matrimonial property system. Let's look at the content of our founding affidavit. We will always, in any affidavit, we will have a description of the parties. So the first applicant is Janine Boltman, an adult female advocate resident at XYZ and who resides in the jurisdiction of this honorable court. And then you will say the second applicant is husband. Husband is a male IT professional residing at number and is resident within this honorable court's jurisdiction. On the 14th of December 2004, we were married to one another in community of property and that the marriage still subsists. We attach a copy of our marriage certificate and mark it as Annexure A. the purpose, and also when drafting your affidavit, it's good to maybe say prior to starting an affidavit, you can cite parties, jurisdiction. Then you give your averments in respect of jurisdiction. Purpose of the application. Purpose of the application, you'll tell the court why you are before this honorable court. And you will say we are before this honorable court as cited in terms of the notice of motion, and then you can cite the praise in your notice of motion that you want the court to afford you an order in terms of your praise, ... You will then also cite if there's children involved. If there are children involved, you attach their birth certificates. You will explain to the court the reasons for the change. You will also give the court a draft notarial contract. You will list all your creditors. You will say to the court, I have published in the Government Gazette a notice to creditors and creditors, and Government Gazette notice 1, 2, 3, 4 as annexure, whatever the annexure may be. Also submit to this honorable court that on such and such date a newspaper notice was sent out in the Bergen, and the newspaper notice is attached here to and marked as annexure. Letters to the creditors, you will indicate to the court that your letter to the creditors has gone out, and you will then attach all your letters. You will attach it. You will either attach all the letters, or you will have one draft letter to creditors, and you will attach your form of service to that. So you either sent it by a registered post, or you served it via the sheriff, then you will attach the necessary return of services. You will then set out the financial position of the parties. So this will usually be done in the form of a balance sheet of spouses. So you will have a balance sheet of the spouses' assets and liabilities. You will then also indicate to the court that neither of the parties have been sequestrated. Neither is there any pending litigation against any of them. In conclusion, we therefore pray for an order in terms of the praise found in our notice of motion. So that is the gist of what should be found in your founding affidavit. All right. So let's now move on. Let's just touch on the issue of antenuptial contracts. So when your client comes to you, I'm sorry, but I don't have any, I don't have a slide for antenuptial contracts, so I would just like everybody to listen. When you consult with your clients are coming to you as if they don't know. So you need to explain to them as if they don't know anything. You need to explain, the way I did, the various types of property, matrimonial property systems which is available to them. So you would explain to them the pros and cons of a marriage in terms of in-community of property. You would explain to them the consequences of a marriage out of community of property without the accrual system and with the accrual system. It is vitally important that they understand what each one entails in order for them to make an informed decision. In fact, there is an indemnity on an example of an indemnity in your pack, which basically says and I will read just quickly read what it says. We, the undersigned and presently entering into an antenuptial contract in contemplation of a do hereby confirm that on such and such a day, and then it goes further and it says, Advocate Boltman specifically advised us on the patrimonial consequences of marriages in community of property, marriages out of community of property in terms of an antenuptial contract, subject to or excluding the accrual system. Please have your clients sign these indemnities. The last thing that you want happening is for you to have been reported to the Law Society and saying that you did not properly advise the client, or even being taken to court that you did not properly advise your client. So have the clients, your clients could sometimes be your worst enemy, so have the client sign an indemnity, all right, which stipulates that we understand that he or she has explained all three property systems. We understand it to the best of our ability, and all right. So please indemnify yourselves. Then also make sure, as a candidate attorney at present, or as somebody who is not admitted as a notary public, you may execute or you may draft an antenuptial contract. Okay, you may draft an antenuptial contract. Even myself, not being a notary public, I can draft an antenuptial contract. I can present it to my clients. I can also discuss the terms thereof. However, the client may also say, listen, I don't have time running around to a notary. I'm going to give you a power of attorney to sign the antenuptial contract on my behalf before the notary public. All right. Then you will sign an antenuptial contract. You will sign a draft antenuptial contract with the parties will sign a draft antenuptial contract. They will sign a power of attorney, which gives you the authority to sign on their behalf before a notary public. They will then sign personal affidavits in their personal capacities, saying that they are unmarried, that their ID number is X, Y, and Z, and that they've never been sequestrated. They will then also issue you with the joint power of attorney to sign on their behalf, with the anti-draft, anti-nuptial contract, and they will also submit a copy of the IDs to you to ensure that their names are typed in or are typed in correctly. Okay, always make sure names and IDs are always correctly cited in your antenuptial contract. If not, it will be rejected by the deeds office. Once you have the relevant documentation, you make it in duplicate, all right? You then appear before the notary public and you can then sign on behalf of your client, all right? You may then sign on behalf of on behalf of your client. The notary public then will lodge the necessary documents and will also then have make sure that it is registered at the deeds office, and it must be registered within 3 months after execution. Okay, must be registered within 3 months after date of execution. Alternatively, if you are a notary, you can do everything that I've just stated. And a notary and the parties then sign, the parties in the individual capacities then sign before a notary public. All right. Now, what if the antenuptial contract is executed late or registered late? You can then bring an ex parte application to court for condonation for late filing or execution. Okay, it must be the Act, Section 88 of the Deeds Registry Act says it must be made within a reasonable time. Now, you need to, in your application or in your affidavit, you need to, as a legal representative, you would need to tell the court, I am bringing this application within a reasonable time from the date of us finding out that, or from us discovering that it was not properly executed or registered. You must also show the court that you had the necessary intention to have the antenuptial contract executed on time, or in fact registered on time. All right. So you need to show cause, and you also need to show the court we are bringing it within a reasonable time after finding out. Okay. So it's all about what you stipulate in your affidavit. Okay. Please also ensure that your antenuptial contract is not vague and embarrassing, and that it's not inconsistent. If a court of law considers a document to be vague or inconsistent, the document will be considered void, and the marriage will then be considered or deemed to have been concluded in terms of community of property. So please beware of the various clauses in your antenuptial contract, and that they do not contradict one another, or they are not vague or inconsistent with one another. Okay, and I will refer you to the case of Bath versus Bath. No values were stated in respect of assets listed. The two clauses contradicted one another, and therefore the court found that the antenuptial contract was void for vagueness, and therefore the marriage was considered in community of property. What I would do in an instance like this, just in my personal capacity, if a client were to come to me and say, we picked up that our antenuptial contract is vague and inconsistent, we've always had the intention of having an antenuptial contract concluded, we have always operated under the premise that we were married out of community of property, then I would bring an application to have this rectified, and obviously have my property, my marital property regime considered as out of community of property. Okay, so that's just what I would do if a client were to come to me in that particular instance. I just want to say that an unregistered antenuptial contract can be binding between the parties. All right, it's binding between the parties, so it's binding inter partes. So I refer you to Odendaal versus Odendaal, the case of Odendaal versus Odendaal. I also refer you to the case of S versus S, which is a 2015 case. In S versus S, the attorney with a power of an attorney with a power of attorney failed to register an antenuptial contract, and at divorce, the parties noticed that the ANC was never registered, and the court found that for all intents and purposes, the intention of the parties was that they were to be married out of community of property with the accrual, and therefore found that it was valid and binding between the parties, and therefore the court then had the marriage dissolved in terms of the marriage being out of community of property with the accrual. So it all depends on the intention of the parties and what the parties have intended. So go and read those case law. Right, so let's move over to the issue of divorce. Now, With any consultation, you are going to FICA your clients. You are going to make sure that they provide you with a copy of their IDs and proof of address not older than 3 months. That's what you do first and foremost in any consultation. So when clients come to you with an issue of divorce, please be very sympathetic. It could be an emotional time for the parties. Try and ascertain, get the background, get the facts. Try to ascertain from the client what exactly it is that they would like. Once you've listened to the client, and please do listen, you will then hear what the client has to say to you, and you would be able to pick up what the client wants out of the divorce. And then you can go into explaining the relevant legal principles to the client, to maybe say to the client, no, sir, unfortunately, in your case, you won't be able to get an order for forfeiture because your wife, although maybe she's not working now, she was always contributing towards the joint estate. She did look after your children. She brought a part to the estate, all of those things. So you would need to explain to the client what his legal standing is in terms of the legal principles. Then also I would like you to always ascertain whether there's an opportunity of reconciliation of the marriage. Okay, you need to find out, is the parties willing to reconcile? You also need to find if there's no opportunity for reconciliation, because most times parties are coming to you, they've decided they want to get married, they want to get divorced. So then you would ask them, would they like to settle? Can we attempt to settle the matter? And I would urge all of you, being at this level in your careers now, to urge settlement. We are moving towards a settlement, or we have moved towards a settlement-based approach in terms of litigation. And that is why Rule 41A, please go and familiarize yourselves with High Court Rule 41A, which indicates, or which is a notice to indicate that you are amenable to settling the matter. All right. Also, if you don't, if you do not comply with Rule 41A, it could show the parties disingenuous sort of conduct or behavior, or his temperament, and a punitive cost order can be taken against your client. So please encourage settlement as far as possible. Particularly if there are children, I would again like you to encourage settlement. Even if settlement can't be reached on the merits of or rather on the patrimonial benefits, try and reach a settlement in respect of the children as far as possible, so that the children do not get involved in the acrimonious high conflict relationship between the parties. So always, as far as possible, try to reach a settlement there. So what you will do is, you've now got 3 instructions, you've listened to your client, you've advised your client that you feel settlement is always, that settlement in terms of Rule 41A is now mandatory, and so you need to include that as a possibility. And you would then phone, or once your summons is out, you would phone or write a letter to propose settlement. Even if the summons is not out, and the party, you could give the other party a call and say, hi, Mr. Husband, I'm calling from the offices of Advocate Boltman. We represent your wife in a pending we believe that you are going to be divorced. That's obviously if the party does know that they are going to be divorced, and we would like to know if there's any opportunity of settling this matter so that we can conclude this matter swiftly and have you divorced in terms of a consent paper or settlement agreement. All right. Or you could issue out summons. Once summons is issued and you are aware that the other party has received the summons, you may phone or write a letter to propose settlement. Hopefully settlement can be reached via correspondence. Maybe there's not as many issues that needs to be sorted out and can be reached via correspondence. If not, you can ask for a roundtable conference. Now, I am aware that we, as practitioners, don't get skilled with the necessary tools to mediate, and that we have to go outside the bounds of our university or even outside the practice to get a mediation certificate or school ourselves in mediation. But I would just like to say, don't discuss the merits at your roundtable conference where you are trying to settle. Don't also go into a roundtable conference with an acrimonious stance. Not acrimonious, sorry, adversarial stance. We are trying to reach settlement, and your client also needs to know that settlement is about giving and taking. All right. So both parties need to give a little and they need to take a little. All right. So please prepare your client to remain as calm as possible. You're not going to be discussing the merits of the case. You are merely trying to see where you can reach middle ground with one another. If there's an inability to be settled by a conference, propose a professional mediator before embarking on costly litigious processes. All right. And then we have discussed Rule 41A, which again goes hand in hand with what I've indicated about mediation. So also very important, discuss the costs with your client, discuss your hourly rate, discuss what an undefended divorce or unopposed divorce is going to cost you and what a defended divorce or opposed divorce is going to cost the client. All right, please discuss that with them so that they are aware to what extent they are going to be litigating in terms of costs. So let's go to the grounds for divorce. So Section 4.1 of the Divorce Act 70 of 1977, then 1979, there has to be an irretrievable breakdown of the marriage. If there's no chance of reconciliation, there must be no chance of reconciliation, no prospect of reconciliation. Example set out in Section 4.2 of no chance of reconciliation, no prospect. And it's also evidence that you would need to lead upon divorce. You would need to tell the court there is no chance of reconciliation or no prospect of reconciliation. We no longer live because we no longer live together as husband and wife. We've drifted apart. There's been a loss of love and there's been a loss of affection. We no longer live in the same house together. We haven't been living together for the past year. Or if they do live together, that the bonds of marital relationship in terms of consortium, which is love and affection, that no longer exists. Adultery is also a ground, and you could say that adultery is no chance of reconciliation, no prospect of reconciliation because he or she has gone outside the marriage already. or the party is living with a third party. There could be abuse, or the person could be an habitual criminal. Okay, so those are your grounds which will show no chance of reconciliation or prospect of reconciliation. And you need to lead this evidence when you place your client in the witness box. Section 5, this could be another ground for divorce, is the person has an incurable mental illness or is in a continuous state of unconsciousness. If that is the case, the person needs to be, a curator ad litem needs to be appointed so that the curator ad litem can look after the interests of the person suffering from the incurable mental disease or the continuous or is in a state of continuous unconsciousness. Please note, the court has no discretion to deny a divorce. All right. If one party wants to get out of a divorce, the party wants to get out of the divorce. You can't force a party to stay in a divorce or in a marriage any longer. With a customary marriage, the grounds for divorce is also irretrievable breakdown of marriage, and you would also come before a court to declare your marriage dissolved. Right. So who has jurisdiction over divorce matters? It's your high court or your regional court. Please, again, when deciding to put your client through exorbitant high court litigious costs, please speak to your client about the possibility of putting the divorce through the high court or the regional court and discuss costs with them so that they are aware as to what they are, going into if they are going to be entering the high court for assistance in the divorce. Also keeping in mind that the high court route is also very, it's faster, it's generally faster than the regional court. And if you are 100% sure that your matter is going to end up being settled, by all means, please do put it through a high court. And obviously, if your client has the costs or has the funds. If you envisage that it's going to be a long, protracted, lengthy, and your client is not by the means to afford all the litigation that may come their way, please put it through the regional court. Do not do your client the injustice of running a matter in high court, having to employ an instructing attorney as well as counsel. So your client needs to be well informed when making the decision of whether or not to place the matter in the high court or the regional court. So it will be in the high court or the regional court in the area where either of the parties are domiciled or ordinarily domiciled for a period of 1 year prior to the date when the action was instituted. There must be a reasonable degree of permanency. If the party instituting is in an area for a holiday, of course, that particular court in that particular area will not have the necessary jurisdiction. So let's say, for instance, I was living in Dubai, but I was there temporarily, but I've always considered the Western Cape to be my permanent residence, then your divorce will be instituted in the Western Cape High Court or in the regional area where I reside. Okay. Notice of intention to defend. Please note that if the defendant is 150 kilometers away from court away from the court with jurisdiction, notice of intention to defend shall not be less than 1 month in terms of the Superior Courts Act 10 of 2013 and 10 days in any other case, or 2 weeks. Okay. So jurisdiction in respect of the various care and, in respect of care and contact of minor children, guardianship or maintenance orders. Again, I would say it is primarily the court where the children are resident. That particular court will have the jurisdiction. Or the court where both parties are domiciled will have the jurisdiction. The court where the children are primarily resident, where the interests of children are of primary importance, South African courts will not be bound by the decision of a foreign court. So if a foreign court has made a decision and the interest in the well-being of the children based on the best interest of the children is now being affected, the South African courts will then have the necessary jurisdiction to deal with the matter. Actions to declare marriages null and void or voidable. It will be the court in whose jurisdiction the marriage took place, or where both parties are domiciled, or one of the parties are domiciled, or when voidable, any of the parties' domicilium. Okay. Generally, we go on where either of the parties reside. In cases of care and contact and guardianship of children or maintenance orders, it will generally be the area in which the children primarily reside. Okay, that's what happens in practice. Validity of a divorce order, annulment issued by a foreign country. It is recognized by the courts if one of the parties were domiciled in that country, region, or ordinarily resident in the country or had nationality. So it will be recognized by our courts. So children and divorce. Now, this is a topic which is very near and dear to my heart, and I take issues pertaining to children very seriously. And as prospective officers of the court, I just want to have the candidates remember that as officers of the court, your interests are first and foremost with the best interests of the children at all particular times. All right. So that said, when there is a high conflict or acrimonious or adversarial or there's adversarial litigation about to be instituted, or there's acrimonious relationships, or there's high conflict between the parents, please encourage your client to, as far as possible, think about the best interest of the child first and foremost. And the best interest of the child is highlighted in section 28(2) of the Constitution. And the best interest criteria is also set out in section 7 of the Children's Act, and has also been identified in the case that I'm sure everybody has had sight of during university days, McCall versus McCall. I'll say this again. As legal practitioners and as officers of the court, our duty is the best interest of the child. So if your client says and comes to you and says, I don't want this man involved in my children's life because he does not support them financially, or he they give all sorts of reasons why children are not allowed to see their parents, then please advise them that as an officer of the court, the best interest of the child is of paramount importance. And in terms of section 7 of the best interest criteria, and in terms of the Children's Act, the Act says every child has the right to have contact and have a relationship with both parents whether unmarried or whether married. Okay, so deter your client from being or becoming adversarial as far as possible. If, however, the child is in danger and your client comes to you and says, my child is in danger and it's not in the best interest of my child to be, that is, of course, something completely different. Okay. I also want to encourage candidates as future practitioners to familiarize themselves with the concept of the parental alienation syndrome. So parental alienation syndrome is where a child and the I'm going to use the word alienated father has in the past, or mother has in the past, had a very good relationship with the child, but because of ensuing divorce or pending litigation, divorce litigation, or um, separation between the parties, mom or dad, whoever the children is in the care of, let's for this example purpose use mom is in the care of the children. She's now disallowing her children from seeing dad. All right, for whatever reason, she withholds contact with dad. She has a conversation with friends or with family members stipulating that he's such a terrible father, he's no good, he's useless. Be mindful and also have your clients be aware of how they speak in front of their children, because the alienated parent, so what will happen is you have the child and you have the parent who previously had a very good relationship and very good interaction with one another, but as a result of the act of parental alienation, which is exercised in the form of an action by the parent, usually who has primary care, now suddenly the child no longer wants to have any form of contact with the other parent. The child all of a sudden says, I don't want to come to you, Dad, or I don't want to visit grandma. And when I mean grandma, I'm referring to the paternal extended family. So you will notice that there's a shift in the child's behavior. You will notice that the child will all of a sudden, it will seem as if they are making the decision, but actually they are reflecting, or they are, the child may be listening to the drama unfolding between mom and dad, and so will make a decision to not want to visit dad, or to keep the peace, or to be favored by the other parent not to visit dad. So those are signs of parental alienation. That's one sign of parental alienation. Other signs of parental alienation could manifest in the child being highly anxious or suffering from extreme anxiety, not having learning disabilities at school. So there are various signs of parental alienation, and I would encourage all the candidates to please familiarize themselves with the concept of parental alienation and what to look out for. Parental alienation, in my opinion, and I would like to have our law progress more in this respect, but parental alienation, in my opinion, is a form of abuse. It is not okay. Each child is entitled to see both parents on condition that the parent is not an habitual criminal who abuses the child, neglects the child, so please, I'm begging all candidates to become familiarized with parental alienation and the syndrome pertaining to that. And when you do notice signs of parental alienation, you need to write to the other side, or you need to make the Office of the Family Advocate aware of that. And possibly you would need to call in the services of a trained facilitator or play therapist who will then now have to reunify the alienated parent and child, because in most cases what you will find from parental alienation is that the child, as stated, no longer wants to have a relationship with the other parent and therefore maybe hasn't seen the other parent for 6 months to a year or even a month and more, and you would need to rebuild the confidence and trust between the child and the parent. Okay. So principles of custody and access becomes, so we don't refer to custody and access any longer, we refer to care and contact. So care would generally be your custody and access would be your contact. So we would now maybe state in a settlement agreement or a parenting plan that the minor children is in the primary, or the minor children will be in the primary care of the mother, and the father will have contact with the minor children every second week. Okay, and then all of the rest of your terms. So primary care, so if somebody's if a child is in the primary care of one parent, that parent has the right to has the right to regulate the child's day-to-day life, where the child stays, living conditions, well-being of the child, protecting the child against abuse, maltreatment, protecting the child's rights, and guiding or advising the child in respect of decisions. Okay, so that is when the child's in the primary care or in the care of a parent at a particular point. That is the decisions, or those are the decisions that the parent is allowed to make. There are instances where parents, in matters that I've dealt with, where parents have agreed to share care between the children. In other words, they would share the children on a 50-50 basis, monthly basis. So either they would have the children stay with mom for 15 days and with dad for 15 days, or they would 1 week on, 1 week off, or there are other ways also to then work out the 15 days. Okay, so every alternative weekend with 2 nights sleepover during the week. Okay, so that's how you would then calculate your shared primary care. And usually in instances of shared primary care, we will get to maintenance. But usually in instances of shared primary care, there's no actual money which gets, there's no actual money which gets transferred to any of the parents, but what they do share is they share the costs or the reasonable costs of the child, such as school fees, extramural activities. So everything, all the reasonable and necessary costs of the child will be shared without there actually being physical maintenance being paid over to one particular parent. So when there are children and there's a pending divorce, in your summons, you will include either an Annexure A or you will include an Annexure B. An Annexure A is a form which you need to have your client filled out and commissioned at before a commission of oaths, and it's filed with the particulars of claim in a divorce action. And the form pertains to arrangements regarding the care of the children and the current circumstances of the children. This one is generally used when we don't foresee any particular issue regarding care and contact with the children. Now, Annexure B can either be filed with the summons or it can be filed with a plea and counterclaim. Okay, here you are asking the family advocate to institute an inquiry in terms of Section 4 of the mediation, in terms of in certain divorce matters. So here you are asking the family advocate to investigate the circumstances of a child, and you're also asking the family advocate to have the child placed in your primary care. Okay. It may be that the father is an alcoholic and is an habitual alcoholic, and the children will not be able to be in his care at all. And so we will need a family advocate's report to the family advocate will then investigate and submit a report, which will then give recommendations. Also, I just also want to mention the family advocate is always given a copy of the summons and particulars of claim. All right. And when a parenting plan has been agreed upon between the parties, it must be submitted to the Office of the Family Advocate for endorsement. And once the Office of the Family Advocate has endorsed the parenting plan, which usually forms part of the settlement agreement between the parties, they will submit a short report which says that we have endorsed the contents of the consent paper which pertains to the children, and we are happy. We are happy with that. We don't have any questions, and the court then there seems to be no issues pertaining to the children or the care of the children. Right, spousal maintenance. So in your divorce, your application for, your summons for divorce and your particulars of claim, you will usually indicate if you are in need of spousal maintenance. Now, there is generally the principle of the clean break principle, which we should try and ensure as far as possible. So the clean break principle says once the parties have gone their separate ways, we would like no further entanglements. So the court will generally look at the age of the spouse, the qualification of the spouse who's claiming spousal maintenance. We will look at the health of the person. We'll look at whether or not that person has children. The court will look at whether or not the spouse is working, also the duration of the marriage. Now, it may be that, somebody is 35 years old, has a degree as a lawyer, but has never worked as a lawyer, has no experience in the legal field, but is educated, has never worked, has been caring for the children, has been caring for the home. The court in such instances will grant that person rehabilitative maintenance. Why? Because the person is 35 years old, the person has a degree in law, the person can go out into the job market and go and get him and establish himself in the labor market and be able to find a job, and will then absolve the other party from maintaining that person. Okay, so that's what we know as rehabilitative maintenance, and the court will then allow for rehabilitative maintenance for a period of time in order for the other spouse for the person claiming the spousal maintenance to get back on their feet. Okay, but these days it's very rare that someone is granted spousal maintenance until death or remarriage. The circumstances must really be that the age of the spouse doesn't allow the person to go back into work. The qualifications, the person has no qualifications. The person suffers from, is not really able to work because of certain health conditions. The person was married and has been unemployed for the last 50 years, for instance. In those instances, and you will also look at the financial position of the other party, but in those particular instances, a spousal maintenance order will be granted up until remarriage, but it really depends on the circumstances of each specific case. So please look at the circumstances of your client and advise your client accordingly. If your client has a flamboyant lifestyle and wants to live a particular life, and you need to advise your client that she is 35 years old, that she can no longer live that life. She has a degree and that she needs to go and work. All right. So Section 7.2 of Act 70 of 1979 says current or expected wealth, financial needs and obligations, age of the parties, duration of the marriage, standard of living before divorce, reasons for the breakdown of the marriage, and any other factors. Encourage you to look at your client's circumstances holistically. Settlement and divorce. I think I've gone into settlement quite a bit, but let's you try and encourage settlement to avoid costly litigious process, but particularly where there are children involved. Your settlement agreement, if there are children involved, your settlement agreement will involve the care and contact of the children. It is please, and I've noted this in many settlement agreements where they, or parenting plans or settlement agreements where they don't mention maintenance and they leave it up to the maintenance court to decide. Please, as far as possible, try and reach an agreement about maintenance, the amount, escalation, according to CPI, or agree to a 10% escalation or whatever escalation you agree to. Tertiary education, medical aid, please be very inclusive when drafting a maintenance clause. Can contact the same, be very inclusive, include things like holidays, birthdays, funerals, Christmases, be very inclusive. If dad is found, or if dad enjoys smoking weed, that parties are not to get stuck on the issue of smoking weed, but just to please regulate. There are ways in which one can regulate certain issues that may come up. Also, always include in care and contact, also always include the facilitator, mediator, and the facilitator's costs. Who is going to pay for the facilitator or the mediator should the need arise for a facilitator or mediator? Okay, so that's in respect of care and contact. Spousal maintenance, if any amount, is it rehabilitative maintenance, or is it a nominal maintenance? You will then have, please don't forget this clause, the Domcasta clause. Maintenance will cease, so you need to say maintenance will cease at remarriage, or if the other party is going to cohabitate with another person, and then you also discuss escalation, all right? Then in the division of patrimonial benefits in your settlement, not even in your settlement, in your particulars of claim, please deal with the items, with the movable items fully. Please deal with the immovable property fully. In other words, mention the name and cite the address, cite the earth number of the immovable property, cite what is going to happen to the immovable property, and if that particular occurrence is not fulfilled, what then? So in other words, if I am going to, I'm going to say the following. Janine will buy the property, 50% of the husband's share in the immovable property. She will ensure that she is able to get the necessary, or get approved for the necessary bond, and be able to pay out husband. If, however, Janine is not approved for the immovable or for a bond pertaining to the immovable property, the house will be sold within 3 months after this divorce order is granted. So the house will then be sold, and then also include what if one of the parties do not want to cooperate. So if husband does not want to sign the necessary transfer documents, have a clause placed in the divorce summons that the sheriff of the court will sign the necessary transfer documents on husband's or on the necessary parties' behalf. All right. So you make allowances for every particular circumstance which may occur. Pension interest, you will mention the pension interest. You will make sure that you cite the name of the pension interest and the fund number. You will also ensure that your clause is correctly drafted. If it is not correctly drafted, if the pension fund is not correctly cited in name or in reference number or fund number, the fund will reject your claim when your client wants to make application for her half share of the pension, her half share of the pension fund. All right, it will be rejected, and they will refer you back to the regional court or the high court for an amendment, for a variation of that particular clause, which is going to cost your client money. All right, so make sure that the pension fund or the pension interest clause is correctly cited and that correctly referred to, and that pertains to annuities, investments, and shares. Also, if the client has businesses, please, or either of the clients have businesses, please cite all the necessary details pertaining to the businesses and what is going to happen. Do not leave any item unaccounted for in your divorce summons. Ensure that you make a list of what property your client and their spouse has in order for you to cover it in your divorce summons. Right, and then you will have a clause for full and final settlement, and you will have a clause pertaining to costs. So just back to the divorce summons. The divorce summons will contain the full names of the parties, gender. The gender must be cited, address or place of business and occupation of the parties. The relief is claimed in terms which is claimed in terms of the particulars of claim, and you will say the relief claimed is in terms of the particulars of claim attached to the summons. You will then stipulate in the actual summons that the parties have 10 days to defend the action. If they do not defend the action within 10 days, a judgment by default can be granted. Service address, always ensure that you have a service address. If your offices are 15 kilometers away from the court, always ensure that there's a service address within 15 kilometers from the court. And then you also inform the defendant that if he or she fails to defend the action, judgment may be taken in his or her absence. All right. Particulars of claim, we were there at particulars of claim. Particulars of claim, I encouraged where we were dealing with settlement in your particulars of claim. You will deal with the division of the patrimonial benefits in full. You will deal with spousal maintenance. You will deal with maintenance, care and contact of the children. All right, so we haven't dealt with the issue of children's maintenance. We've dealt with, sorry that I'm jumping around, but let's just deal with, we've dealt with spousal maintenance. So let's just go to children's maintenance. You will note that in your section pertaining to children's maintenance, you have a needs sheet, which is a calculation of monthly expenses. All right. So when consulting with your client, ask your client to set out the need or the reasonable needs and expenses of the child, okay, or of the children. And you will also, your client is also to set out what their expenses are, okay. And the client is also to provide you with a list of assets as well as their monthly income. Now, once you've determined what your client's gross income is, as well as the gross income pertaining to the other parent, how we work out our maintenance calculation is very important, because we need to ascertain what percentage of the child's needs will be for which parent, okay? So if I earn, let's for argument's sake say I earn 100 Rand and my husband earns 100 Rand. Sorry, my husband earns 200 Rand. All right. We earn a gross income of 300 Rand together, right? So our gross income in total is 300 Rand. My income I've indicated is 100 Rand. The calculation is so then would be 100 Rand divided by 300 Rand. So if everybody can just make a note. We'll take my income of 100 Rand. I'll divide that by our gross income of 300 Rand. Now, the children's needs are, for intensive purposes, say 50 Rand. I will then say 100 Rand divided by 300 Rand times 50 Rand divided by 1. Okay, let's do that again. So I earn 100 Rand. I divide it by 300. I times 50 Rand divided by 1. My contribution towards the child or towards a child will be 16 Rand 66. And my husband, because he is the higher, or he earns the highest income between the two of us, his contribution towards the children will be 33 Rand. All right. If there's any questions, please send me a message and I will deal with it. But I'll quickly just briefly go over that calculation again. So I will say, I'm going to write here, so I will be say 100 Rand divided by our gross income. That's my salary, my gross income. My gross income divided by my income, 100 Rand plus my husband's income of 200 Rand, 200 Rand, which is equal to 300. Child's needs is, so then you'll take that amount And you will times it by the child's needs, which is for all intents and purposes 50 Rand. 50 Rand divided by 1. That will then give you what my portion towards my child's needs are. Okay? Very simple exercise that you should particularly do when going through the child's expenses. All right, now with the summons, what happens if my husband is overseas and the sheriff here in Cape Town cannot serve the documents overseas? There's one of two processes we can follow. We can make an application to court for a dictal citation, or we can make an application to court for substituted service. All right? So those are the two forms. I can make an application via dictal citation or substituted service. Now, a summons must be served on an individual personally. And so with a dictal citation, if my husband is overseas, I then need to do an edictal citation application, which is an ex parte application to court, have the edictal citation application granted. The order, the summons is then drafted. It is issued. It is then given. It is then taken by the registrar of the registrar of the court, who will then hand it to the Department of International Relations, who will then ensure that the person or my husband gets the necessary summons. All right? So that's one way of doing it. The other way of doing it is via substituted service. My husband knows that I want to divorce him. I can then make an application to court to, instead of having the documents personally served on him via dictal citation, I can then apply to the court and say, I've got his email address. Here's proof that he uses the email address. I would like to serve the divorce documents to him via email. Or I have no details pertaining to him, but I do see he's active on Facebook. I would like to serve the divorce summons to him via Facebook or newspaper or WhatsApp. All right? And the court will then allow you, depending on the strength of your application, will give you the order for substituted service. All right. Then we will be concluding soon. Let's just move on to the checklist in an unopposed divorce. If your divorce is unopposed, try as far as possible to conclude a settlement agreement with the other party. It just makes things a whole lot easier. Also, if the divorce is going to be unopposed, ensure that the other party signs a notice of intention of non-defense. A notice of intention of non-defense. Right? Once that is done, you can then proceed with the unopposed divorce action. At the day of divorce, you will have the antenuptial contract. If married in terms of antenuptial contract, you'll have the antenuptial contract with you. You will ask the client to bring the original marriage certificate along. You will present those two documents in court. You will also have a copy of the original settlement agreement with you. And they will be presented to you at during the divorce process at court, or during the finalization of the divorce. So make sure that that is with you. Always make sure that your summons, particulars of claim, have been served on the office of the family advocate. Even if you don't have a copy of the settlement agreement, always serve a copy, if there are children, on the office of the family advocate for the family advocate's approval. And that should be the gist in respect of your divorce actions. So your divorce action could be opposed or undefended, or undefended, or it could be opposed and defended. All right. We use the word defended with actions and opposed with applications, opposed or unopposed with applications. Right, so now what happens if during the course of the divorce proceedings, my husband is not contributing to the joint estates liabilities? He's not paying his part of the bond. He's not paying his part of the water and electricity. He's not contributing to the maintenance of the children. What can your client do, or what would you advise your client to do? You would advise your client to make an application to either the High Court or the Regional Court for a Rule 43 application, which is your High Court application, what regulates your High Court application, and the Rule 58, if in terms of the Regional Court. So you can approach the court to get an interim order for your husband, or for your client's husband, or to order your client's husband to make the necessary contributions towards my maintenance, towards the joint estate's maintenance, and towards the children's maintenance. You can also bring a Rule 43 or Rule 58 on the ground that you are not seeing your children, that you have no contact with your children, or that your client has no contact with your children or their children. You can bring a Rule 43 or 58. You can also bring a Rule 43 or 58 if your client needs a contribution towards her legal costs. Right? You can also bring a Rule 43 application if your client wants primary care of the children. Temporary primary care until the issues of the pertaining to the divorce have been settled. Now, a Rule 43 application should be a very minimal application. When I mean minimal, you need to, as the applicant, you need to place as much information pertaining only, if it's got to do with money, pertaining only to the financial circumstances of the estate and of yourself and what is happening. All right? You do not go into in your affidavit, you do not go into the merits of your divorce action. You do not say he's committed adultery and he's done this and this is his misconduct. We are not busy with a divorce trial in a Rule 43 or 58. You stick to the reason why, or in your application, you stick to the reason why you are approaching the court. You're either approaching the court with regards to maintenance for yourself, maintenance for the joint estate, maintenance for the children, a cost contribution for legal costs, contact with the children, or primary care of the children for the time being. Those are the only facts you deal with in your papers. You will also ensure that your application deals with if it's financial, that your application deals with all the finances pertaining to the estate, all your finances, and you will also submit proof thereof. All right. So very important that you only stick to the necessary, that you stick to the nature of the application, and that you do not go place a second divorce file as part of your application. The court, well, in the High Court, they frown upon that type of conduct. Also, you are limited to 2 sets of affidavits. All right. You are limited to your founding affidavit, and the other party is limited to his or her opposing affidavits. All right. So those are the only 2 sets of affidavits, unless the court condones a further set of affidavits. Those are the only times that you will go outside the requirement of 2 sets of affidavits. If you are dealing with the issue of care and contact, you need to stipulate to the children, you need to stipulate to the court that that your client is being withheld contact, and it's been ongoing for a period of 3 weeks. There is no valid reason for contact to be withheld, and you stick to the facts only. Do not go into the merits of your divorce matter. All right. It's supposed to be a swift, speedy application, so you need to deal with it as swiftly as possible, also to curtail as much cost as possible. If the court finds that you are acting outside any of the requirements or any of the directives pertaining to Rule 43, they can order that that a cost order, de bonus proprius, be granted against you as the practitioner. So please keep your Rule 43 in line with what your application or what your praise is asking for. All right, it is very imperative that you do that. All right, ladies and gentlemen, we are going to conclude on that note. If there are any questions, please do not hesitate in asking or rendering your questions. I do see a few questions. Let's see if we can see if I can go through a few questions before we log off. I also don't mind any questions coming to me directly. Let's just start. All right. If you have any questions, you can also directly email me, and you can email me to that address. Here's a question: unopposed divorce from Petrus Skumanlo. Unopposed divorce, the defendant refuses to sign the notice of intention not to defend or enter into into a settle. Can we still proceed and apply for the decree? Right. So if the unopposed or undefended divorce, a notice of intention not to defend or a settlement agreement is not signed, it's fine. You can proceed with receiving a judgment by default. Okay. So as long as the person, so if the person has in fact submitted a notice of intention to defend, but files no plea or counterclaim, you have to issue them with a notice of bar, okay? And give them 5 days. If they don't, if they are ipso facto barred within the 5 working days from, then you may proceed in the ordinary course to place the matter on the roll on an undefended basis. I will send my slides to Prudence, who will then, or you can, anybody can just email me, and I will then send or forward the slides to you. I've noticed somebody said, can an alcoholic or addict also be a reason for irretrievable breakdown of marriage? Yes, it can be. Person can be, just like the person can be an habitual criminal, person can be an habitual alcoholic, or it can be an addict, and that could be infiltrating on the communication. It could also be affecting the consortium between the parties, and so there may not be any reason for the other party to want to continue the marriage. Love, loss of love and affection, those are all reasons. So somebody's asking, is the Actio Paulina utilis similar to a spoliation application? Let me just, a spoliation application is one way of doing it. Spoliation application is also a very drastic remedy. It's a quick remedy. It is when you have, let's say, for instance, my husband, I've always had access to the car. I've always been using the car. I've been using the car to take kids to work. I've been using the car every day. My husband, out of spite, decides to take the car away from me. I can do an urgent application. So it's an urgent application. I can do an urgent application to court to have the motor vehicle placed back in my possession. Okay, and you need not be the owner of the motor vehicle. So you can use that as an urgent application, and you would obviously need to. An Actio Paulina is it's similar. It's similar to a spoliation application. However, spoliation application is rather more, you would need to, in the Actio Paulina, you would need to show that you are in fact, that you had lawful right to claiming the motor vehicle back from a third party, etc. Okay. And also remember, in the Actio Paulina, in a spoliation remedy, somebody has actually deprived you of possession in a spoliation remedy. In Actio Paulina, the third party did not deprive you of the possession. Your partner deprived you of the possession and maybe sold it to a third party without you knowing it. Okay, so they've gotten rid of the asset. Any other questions? I'm just squeezing through. Anything else I see? Okay, yeah, from Angelique Leroux. You indicated earlier that divorce proceedings should be instituted in the jurisdiction where the parties are ordinarily domiciled for a period of 1 year. prior to the date when the action was instituted. How strict are the courts with this 1 year, especially when one of the parties moves away and now wants to institute divorce proceedings? So again, like in my example, let's say for instance, I was temporarily resident in and working in Dubai, and I now return home, and I foresee home to be my permanent place of residence. You can institute, even if you have just been in the country for 2 weeks, you can institute divorce proceedings in the jurisdiction where you reside, or even in the jurisdiction where the defendant resides. Okay, so I hope that answers your question. But one of the two parties must be a resident in that specific jurisdiction. Or if you are like if you are permanently, or if you consider the Western Cape or South Africa to be your permanent home, and you were just temporarily working somewhere else, you can use that particular area as a place of jurisdiction. It shouldn't be an issue. Okay, so what happens? I've got a question from Brandon Kutsi. Without a community of property with a crew, what happens if the net estate is in a negative? Well, remember, I've said one of the estates will always be, one of the estates will always be larger. So the larger of the two estates will then claim from the other. However, if both of the estates are in a negative, I would say draft a settlement agreement and just decide to go your separate ways, and don't claim any accrual, and kind of just put that in your settlement agreement. Then I have a question from Dalian van der Westhuizen. The family advocate situation where child is born from a fair biological father has only been allowed very limited contact, good case of parental alienation, the mother and the husband gets divorced, and our client's child is included in their parenting plan. No mention of our client, and the family advocate condones without questions. Can you in any way report family advocate for negligence? Look, the family advocate, let me just say this, the family advocate is only deals with the issues before it, unless they are asked to investigate a particular matter. Unless they are asked to investigate a particular matter, will they know the full circumstances of a particular situation? So the family advocate needs to be placed into, be given the full picture, whether it be by from the father, whether it be from the mother. But the family advocate will only know what the true circumstances are if both parties are going to give the full set of circumstances. All right, so, but if the family advocate is asked to investigate the matter and they don't investigate and they make a report or they make a finding or recommendations which are not in the best interest of the child pertaining to contact with the actual biological father, you can question the report, or you can ask for a secondary report to be compiled or submitted by another individual. All right, another professional individual, be it a social worker, be it a play therapist, or any other clinical psychologist, child psychologist. So you can ask for a second opinion. All right. I think those are the questions for now. If anybody else has any other questions, I think for now we are then going to say goodbye. I hope that I have shared as much information as I can. And I try to be as practical as I can because anybody can read a set of notes, but it's always difficult to actually put this into practice. So goodbye, and I wish you well going forward.